So I would like to ask Ms. Triin Jaadmaa, I hope I pronounced her name properly, to speak about the Estonian climate case, climate litigation against oil shale. Triin, the floor is yours. Thank you.
Yes, hello everyone. I'm very happy to be here. I hope you can hear me. Regarding my presentation, I would kindly ask if you could show the slides yourself. Would that be possible? As I'm connecting through my phone.
I'm afraid that would take some minutes before I can do that. Let me see how it works. Sorry.
Yes, it's okay. I will start anyway.
Okay, please start.
Yes. Yes, so I'm a legal expert from the NGO called Estonian Environmental Law Center. In my work, I have focused mostly in the climate change issues, and I have been involved in the climate litigations as well. In Estonia, we have had so far one important climate litigation that got a win in the Supreme Court last year, and in a way got a continuation this year. In other words, in Estonia, we have had two climate litigations. They both involve the same object, just the permit we challenge is different. First one involved a building permit, where we got a Supreme Court decision, and now the current case in the court is about environmental permit. More precisely, integrated environmental permit. There have been very interesting cases with important legal questions. Estonian Environmental Law Center represented the plaintiff in these cases and continues to do that. I will introduce you a little bit the object that is under our attack. It is the new state-owned Enefit shale oil plant. This plant would produce oil from oil shale. Shale oil is a fossil fuel. Almost all of it would be exported outside the EU and to be used as fuel on long-range ships. According to studies, if you take into account the different environmental consideration through the life cycle of the shale oil, it is considered as one of the worst fuels there is in the world. So there are little specifications about this plant on the second slide. I have brought out the yearly CO2 emissions, which are in total almost like 2 million tons per year. What is important to notice here is that the CO2 from the production of the oil adds around 6% to the total greenhouse gas emissions that are accounted for in Estonia. This is quite a lot. But the total yearly CO2 from the burning of the oil, it means the scope 3 emissions are even greater. This plant itself does not really fulfill any important state interest. Yes, it creates jobs, but that's not massive. Also, its profitability is very, very questionable. So it's kind of logical that environmental groups have an eye on it. Why do we need an industry in Estonia, a state-owned industry that adds such a huge amount of CO2? Or in other words, takes such a huge piece of carbon budget and creates pressure on other sectors to fit within the climate targets. So we questioned what justified it, what is this overriding interest, how did the authorities account the climate impact and weigh the interests in this case. So there are two court cases involving this plant. First one about the building permit that was issued in 2020. And the second one is about an integrated environmental permit that was issued this year in May. So next slide, I will introduce a little bit climate litigation, Wall 1. So in 2020, we went to court to dispute the construction permit. We went through all 3 court instances, got a loss in the first 2, but a win in the Supreme Court. As we did not get a preliminary injunction to halt the construction, by the time of the Supreme Court decision, most of the plant was already constructed, and all of this with public money, of course. So it created a very interesting situation when the court nullified the construction permit. But I will not touch it now. The important aspects that I would highlight from this decision are as following. Although the case was mostly built on climate arguments, especially on the shortcomings of climate impact assessment, and most of the Supreme Court's judgment focused on climate change matters, the court eventually did not nullify the construction permit on climate change grounds, but because there were other deficiencies with the environmental impact assessment, such as the failure to evaluate the impact on another Natura 2000 area, and also to evaluate the climate sensitivity of the installation. This means the climate adaptation aspect. And this is quite important conclusion, actually, that the failure to evaluate climate resilience of a project can also be a ground by itself to nullify the permit. So regarding climate mitigation, the court found that for this construction permit, the strategic environmental impact assessment did take sufficiently into account the greenhouse gas emissions and its significance. The court found that it was correct to consider the less ambitious climate targets that were in force at that time when the construction permit was issued, although there were already political decisions made to renew the climate goals very soon. Despite that, the Supreme Court gave still very good reasoning on climate change issues, especially on climate impact assessment. The court made it clear that the authority must deny a permit to a project with a significant climate impact unless there is an overriding existential state interest that would outweigh it. Otherwise, it will unduly restrict the freedoms of individuals or the public interest in the future to curb climate change. The greater the risk of missing the climate targets, the greater must be this overriding interest. And this is very remarkable because Estonia does not even have a climate law yet. And we also don't really have yet very clear pathway how to reach our climate goals that are far in the future. But the court implied that even despite that, if the risk of meeting the climate targets cannot be clearly avoided, the authority should not grant the permit to this project. Because in the view of the court, in the case in question, so no such existential state interest can be detected at present. And that was actually, this statement was actually directed to this environmental permit stage. That when the environmental permit is about to be decided, then it should be considered. It should consider these aspects. Also, for the first time in Estonia, the Supreme Court stated that the mitigation of climate change is a constitutional obligation, and more precisely, that the Estonian Constitution requires a proportionate contribution to the Paris Climate Agreement temperature goal. So this case has for sure developed a law in relation to climate change, and it has also made the decision makers take climate considerations much more seriously than before, but there is still a way to go. After the court decision, the municipality assessed the environmental impacts that had not been properly assessed before and decided to grant a new construction permit. And for the environmental permit, there was a new climate impact assessment made to include our new ambitious climate targets that entered into force. Despite that, in May, Environmental Board issued the permit to this plant so that it can operate, but it set the deadline. The plant can operate until our next official climate target, which is set for the year 2035. So until then, the CO2 emissions are fine in their view, because it doesn't affect any targets. And when the deadline comes, the target comes, then the emissions have to drop right away, or it can apply for a new permit. And it's quite absurd in our view. So we had to go to court again, which brings us to the climate litigation Vol. 2. So the next slide. I introduce it a bit. For this case, we added another plaintiff, young climate activist Elole Mara. So we now also use human rights arguments. The arguments in a way are very similar to the previous case, but now the question is, did the Environmental Board really follow correctly the Supreme Court's guidelines? Is it really so that the CO2 emissions from this plant does not constitute a significant climate impact before the 2035 climate target? And what about the cumulative impact and the fact that this plant takes a huge amount from Estonia's carbon budget? And indeed, Estonia has not adopted an official carbon budget yet, but shouldn't it still be considered scientific evidence showing the impact of this plant's emissions? And also, we know that Estonia is obliged to set midterm targets with climate law, also for the period before the 2035 target. And it's clear these emissions from this plant would create a huge risk that we won't reach the new climate goals. And shouldn't that have also been taken into account in the decision making as a risk? And problematically, the Ministry of the Climate is currently planning to set a target for the 2030 with lower ambition implicitly, so that the emissions from this plant will fit in, despite that. That will mean that the ambition will be way less than the Paris Agreement requires, which is very problematic. So that also demonstrates how huge is actually the impact from this one plant. There's also an issue that the plant's emissions would hinder the achievement of the emission reduction targets set out for the year 2030 in the National Energy and Climate Plan. But they say, the Environmental Board states it's not a binding target, as we don't have this target anymore in the official strategic planning documents. But of course, we don't agree here. We argue that the EU law does not allow to retreat from the targets set in the NSCP. So it had to be actually, this target had to also be considered, but they didn't. And also one important aspect is that the environmental permit didn't take into account the scope 3 emissions, that is the emissions from burning of the oil, which is actually greater than the emissions from the production of the oil. And we argue that this is also an important error. So indeed, there are many important legal questions to be decided through that litigation. And regarding the timeline, the administrative court hearing will be on the 2nd of December, and the decision will be out hopefully in the beginning of next year. So keep an eye on this exciting climate case. And that will be all from me. Thank you very much.